this video, we are going to look at Coronavirus Business Interruption Loan Scheme, and we will learn some basics. If employers need short-term cash flow support, they may be eligible for a Coronavirus Business Interruption Loan. This scheme will remain open until 31st of March 2021 and can also be used to pay salaries and wages. So what is the Coronavirus Business Interruption Loan Scheme? This scheme is designed to support those employers who have a borrowing need which are considered viable by the lenders were it not for the COVID-19 pandemic. So even if it is minus COVID-19 pandemic, otherwise the business proposal should be viable. The borrower remains liable for the entire loan amount and the lenders will seek to recover the outstanding balance of loan from the borrower. Although there is a government guarantee for the lenders will only look towards that before they have exhausted options with the borrowers, as well as the proceeds of any security, for example, or any security provider on the borrower's behalf has given for the loan. Are any guarantees, for example, personal guarantee or home, required as security for the loan? In respect of the loans up to 250,000, no personal guarantee will be required. If the borrowing is more than £250,000, the lending institutions may ask for guarantee based on individual circumstances. So what will happen if the borrower fails to make payment on the loan after 12 months? The government will be paying fees and interest for the first 12 months on the borrower's behalf. If you are concerned that you will not be able to make repayments, you need to contact your lender and explain the situation to them. What is the eligibility criteria for the scheme? There are a number of criteria. Number 1, business to be based in the UK. Number 2, the funding required to be used to support business activity within the UK. Number 3, 50% of the business turnover generated from trading activity, regardless of whether profit was made or not. Point number 4, business turnover less than £45 million and must not have been more than £45 million per year in the 12-month period preceding the application based on latest annual accounts. Number 5, you have to be in the eligible sector and eligible purpose related to COVID-19. The ineligible sectors are banking, public organizations, primary and secondary schools, etc. There are also some restrictions around fisheries and agricultural products. Point number 6, the amount required is for 6 years or less and is between 50,001 and 5 million. Number 7, self-certify that it has been adversely impacted by the coronavirus. Number 8, in addition, the business need to meet undertaking in difficulty test, as defined in Article 218 of the Commission Regulation number 651/2014. You will satisfy the test if you have fewer than 50 employees and less than £9 million in annual turnover. And number 9, the borrower will also need to provide the evidence of the viability of the business were it not for the pandemic. Out of all these points, there is an important point that we discussed at number 8, which is what is undertaking in difficulty test. This is a slightly complicated test for businesses of different statuses, however, can be summarized as follows. Smaller businesses with fewer than 50 employees and less than 9 million in annual turnover and or annual balance sheet will not be considered undertakings in difficulty unless they are A, subject to collective insolvency procedure under national law, or B, in receipt of rescue aid, which has not been repaid, or restructuring aid and are still subject to a restructuring plan. Smaller businesses with more than 50 employees or more than 9 million in annual turnover and or annual balance sheet will still be subject to the undertaking in difficulty test, as defined by the European Union. Applicants will need to determine their turnover and number of employees in line with Commission recommendation of 6th of May 2003 concerning the definition of micro, small and medium-sized enterprises. We will look at what small and medium-sized enterprises are. You would be considered an undertaking in difficulty at the relevant time if you are not a micro or small enterprise and accumulated losses greater than half of your subscribed share capital. Other points in relation to consideration as undertaking in difficulty is that you are subject to a winding up order, a voluntary liquidation with confirmation by the court, an administration, a voluntary arrangement or sequestration or bankruptcy, or under English law, you fulfill the criteria to be placed in any such insolvency proceedings. Next point is you are in receipt of rescue aid and have not reimbursed any loan or terminated any guarantee received as part of this rescue aid. Next point, you are receiving restructuring aid and are subject to a restructuring plan. Or in case you are not an SME, your book debt to equity ratio has been greater than 7.5 to 1 and your EBITDA interest coverage ratio has been below 1:1 as confirmed by the last two sets of annual accounts published prior to the relevant test dates. You may seek accountants' help in relation to these matters. You must meet both of these tests in both years to be considered an undertaking in difficulty for the purposes of the date in respect of which the test is being carried out. In assessing whether you meet the insolvency ratios, you should first identify whether the business is an undertaking in difficulty as at the date of your application, using the two sets of annual accounts most recently published prior to that date. If the business is not an undertaking in difficulty as at the date of your application, there is no requirement to conduct the test in relation to any other dates or periods. If the business is confirmed to be an undertaking in difficulty as at the date of your application, you will also need to determine if the business would have been considered an undertaking in difficulty as at 31st of December 2019. If the business is an undertaking in difficulty at the date of your application, but it was not an undertaking in difficulty as at 31st of December 2019, it will in principle be eligible for the scheme. If the business is an undertaking in difficulty at the date of your application and was already an undertaking in difficulty on 31st of December 2019, it will not be eligible for the scheme. What supporting documents you need for the application? Well, you will need to provide certain documents when you apply for a CBILS backed facility. These requirements vary from lender to lender but are likely to include historic accounts, management accounts, your business plan and assets details. If you do not have all these supporting documents, a CBILS loan could still be an option in order to provide finance to support your business. And finally, just to put things in perspective and just for reference purposes, what is SME, small to medium sized enterprises? You are engaged in the sale of products or services. You employ fewer than 250 people and your annual turnover does not exceed 50 million euro or your annual balance sheet total does not exceed 43 million euros. I hope this introduction to furlough scheme, self-employed income support scheme and coronavirus business interruption loan scheme or CBILS have given you some background information. See you in the next video with sickness and sick pay issues.